Good morning. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with the labor attorney Jung Bong-soo, we will discuss about an article published today by Labor Daily, which is regarding the petition police, security guard, who were doing the watchkeeping, but their compensation was very low compared to the ordinary daily rate. So could you explain about the story about this article?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Thank you for asking. This is about whether watchkeeping time on a weekend can be working hours or not. So company, the name of this company is the Bank of Korea. They hired about approximately 60 private police. Then they had them work on normal day. Also during weekend, they had to watchkeeping job for 24 hours. So this company just paid a fixed amount for watchkeeping duty during the weekend. So that was a small amount, only 60,000 won per day. They worked 24 hours. So later, group of the private police claimed they were not paid properly for their overtime. So they said they claimed that watchkeeping is normal work, it's working hours rather than just watchkeeping.
I see. So, so the court ruling made the decision that this watchkeeping job by the security guard should be considered as the ordinary daily job. So the result was that it's a big compensation for them.
Yeah, so the main issue is watchkeeping job is working hours or not. So to be a watchkeeping job, they must have freedom to come and leave. Also, they can choose to stay for a certain time. But in this case, they are forced to stay in designated area for 24 hours on weekend. So even though they named it watchkeeping, but seems to me as a labor attorney, they had to stay and they had to wait in designated area in order to prevent any accident or special case, because that is a bank building. So then the court ruled such a waiting time should be regarded as working hours. The watchkeeping is not something like watchkeeping for temporary, but in this case they worked during the weekend for 24 hours. Also they had to stay in designated area. So then this is a kind of waiting time. Waiting time is regarded as working hours according to the Labor Standards Act.
So this case was by the Bank of Korea case, but I understand that there might be a number of similar cases. So in such case, like this court ruling, they need to have an appeal to get the decision.
Yeah, court. They usually make the same the decision about this kind of waiting time. So a few years ago, one case like apartment guard, they worked 24 hours. So during night time from 12 p.m. to 5 a.m. They could stay in bed in their working area. So whether such a sleeping time at the workplace can be working hours or recess. So in that case, the court ruled even though they sleep at workplace, but they have to respond any accident case. So such a time to wait for any potential case, such a time should be regarded as a waiting time. Also, waiting time is regarded as working hours. So in this private police cases, it's the same. Even though they say it the watch keeping, but they had to stay in one area for 24 hours. So it is like waiting time to prepare for any accident case. So this is as this is working hours, they must pay the overtime or holiday work. But in this case, the Bank of Korea only paid the fixed allowance like 60,000 won per day. So court ruled this is working hours, so they must pay the difference between fixed allowance and actual overtime work.
So that means that even they are doing the watch keeping and without having to handle any client, they need to be paid as ordinary daily wage. So I think it will make a very big effect to many other different employers.
Yeah, I think so. Yeah, I fully agree with your comment.
Thank you very much for your comment.
Okay, thank you for watching. Bye bye.